Thank you to all of you that have participated and joined in on this webinar. I think we got a good one for you tonight. We'll be talking about national case law and trends around the nation, as well as laws here in the state of Utah that affect your association. To get us started, let me introduce myself. My name is Scott Anderson. I'm with Community Association Management. I'm also on the board here down at the Utah chapter of CAI, Community Associations Institute in Southern Utah. We also have Carson Bagley and Quinn Sperry, who will be presenting to you this evening as we go through this presentation. As we go through the presentation, if you have questions, go ahead and throw them into the question field, and we'll do our best to make sure to get those answered for you. To get us started, we'd like to give a special thanks to all our sponsors. The sponsors are what make education programs like this possible, so we want to give a special shout out to Udi and Associates, Advanced Community Services, Community Association Management, Gothic Landscape, CCMC, PMP Management, Straight Stripes, Sunwest Management, Red Peaks Roofing, Jenkins Bagley and Sperry, who is presenting tonight, ProVent, Max Maintenance, Century West Insurance, FCS Community Management, HOA Living Network of Communities, Companies, and Holbrook Asphalt. Those are really sponsors and partners that help make your associations run well, so please support them as they provide educational opportunities. To get us started a little bit before we jump straight into the presentation, we want to start off with a poll. So we're going to make sure that this is okay. So it should show up onto your screen here. Go ahead and click on the poll, make a vote. So here it is. So, given the issues with COVID and other limitations, can the board pass a rule just by email? We'll give you about another 30 more seconds to respond. And we'll see here what we got. Looks like most of our votes are in. Nothing's changing, so we'll go ahead and close up this poll and see where we got. Give me just a second. All right, so here we go. This is how people responded. So 58% of you said that is true, and 42% of you said that's false. We will find out in just a minute if that is true or false. So like I said, here we go. Jenkins, Bagley, Sperry are presenting. Carson Bagley and Morris and Quinn Sperry are presenting. So we'll turn the time over to them and let them get going.
All right. Thanks, everyone, for joining us on this beautiful evening. If you're in St. George, there's just a slight bit of rain, but it's not snow like up in Salt Lake. So we're happy about that. Hopefully this webinar is productive and we provide some information that is helpful to each of you as managers as well as board members of your HOAs. And again, having served as a board member of an HOA, I understand the paycheck is large and no good deed goes unpunished. So we hope to help you out and guide you in the right direction here. So let me see if I can take control of the screen. We'll start off with our great disclaimer of this isn't legal advice. Every situation requires that you look at the governing documents and consult with other professionals on matters that need legal advice. So tonight we're going to cover I'll start off with recent cases from Utah, and when I say recent, it's 2019 and forward. because it does take a little bit of time to get published opinions, and a lot of the cases started out many years ago. But we have these cases from the Utah Court of Appeals and the Utah Supreme Court. To start off, just like any good evening, we're going to start talking about a drive-in movie theater who sold the property to a developer, and the property was developed into a community association. When the drive-in theater was operating, as you can see on the screen, you have a disputed strip of property. Back in the day, the dotted line along your screen, and I'm not sure if you can see my mouse, but the dotted line following that, there were fences and trees along the property. And for years, the drive-in property owner, as well as the adjacent property owners, treated that as the boundary line. Developer develops into an HOA and deeds the property by legal description where the dots are to the HOA. Later, you have tax hawk property and Vandalay property that bring an action claiming that they own the property up to the disputed line where the dots are. So what happens when we see it as driving into the drive-in theater to watch our favorite movie? Is that the legal boundary of the HOA, or does the HOA own all the way up to the actual boundaries depicted by the solid line? Go to the next slide here. This is the Pioneer HOA versus Tax Hawk 2019 Utah Court of Appeals case. What people see is not always what is the truth on the legal boundary. Here, the HOA pursued a boundary by acquiescence claim, claiming that they owned all the way up to the disputed boundary line. Obviously, the tax hawk claimed that they had quiet title to this disputed area that was depicted in the previous slide. At the trial court level, the court ruled that the HOA, as the predecessor to the developer, who was the successor to the developer, who was the successor from the drive-in, that the property was the HOA's. Tax hawk argued that no, they owned the property up to the tree and fence line, and the trial court ruled in favor of tax hawk, saying that they owned up to that line. The case on appeal was remanded back, and there's kind of an interesting fact scenario. First, there's number one lawsuit filed. There's no deed to that disputed area, not to tax hawk and not to the HOA as the successor to the developer. In the interim, the HOA obtains a deed from the drive-in owner who had possessed the property for 20 years and treated the fences and the trees as the boundary, which changed the facts for the Court of Appeals. The Court of Appeals ultimately held up, came back and said, this needs to go back to trial. There's issues of fact that need to be determined as to whether the HOA, now that they have the deed for the disputed property, whether they're the owner via boundary by acquiescence legal doctrine. So the point in this case is, just because you see a fence or trees that you think are the boundary doesn't mean that that is where the legal boundary of the subdivision is. And in this situation, most likely the HOA will come out ahead, where they were able to obtain the deed from the drive-in owner, who for at least 20 years and more treated the boundary as the fence and the tree line. We'll move on to our next exciting case after we get through with drive-in movies, to Vanderwood versus Woodward. This deals with, it's a 2019 Utah Court of Appeals case, deals with a garage that was constructed in a subdivision where the CC&Rs had an ACC committee and required ACC approval of improvements. So a fairly common clause in CC&Rs. Unfortunately for this HOA, the ACC hadn't been active since the developer started the subdivision. The homeowners therefore thought, there's no ACC that exists. Why would we go and obtain approval from an ACC that is non-existent? So they constructed a garage. It was not approved by the ACC. Then they get into litigation with their neighbors who say, hey, you failed to follow the CC&Rs by failing to obtain approval from the ACC. The homeowners or the owners of the lot that constructed the garage said, how do we obtain approval from a committee that does not exist? The Court of Appeals came down and said, found that the ACC, because it did not exist or was not active from the outset, was abandoned. But does that mean that all ACC provisions related to construction of the improvements are also abandoned by the fact that the ACC isn't there to approve and enforce? The court went into analysis on that and determined that it's not just because one covenant is abandoned doesn't mean that all covenants are abandoned. And to find that a covenant has been abandoned, it must be something that is other than non-compliance of slight, unimportant, unsubstantial, or of a minor nature that does not destroy the general building scheme or is inoffensive. So the takeaway on that case, you may have, as many associations that we've encountered in our practice, an ACC that has been inactive for years. That doesn't mean that all of the architectural requirements or the requirements under the CC&Rs are abandoned. Simply the requirement for approval by an ACC may be abandoned because the ACC doesn't exist. So it's a case-by-case basis. Waiver of one covenant doesn't equate to waiver of all covenants of the CC&Rs. Let's see. Now
Carson, there's a question about this.
All right.
Hey, Carson.
Sure.
Question. So does this case apply to other CC&Rs or is this strictly just ACCs? So like if a board has not enforced a covenant for a certain amount of time, do they lose their enforceability under this case law, or is this strictly strictly confined to the ACC portions?
Not to be cliche, but it does apply across the board. So whether it's an ACC covenant or another covenant within the CC&Rs, it is, the abandonment of one provision of the CC&Rs doesn't equate to the abandonment of all provisions of the CC&Rs, whether they're ACC related or related to some other provision or covenant within the CC&Rs. Good question. Hopefully that's responsive. So a sister case that came right after this case, the Timber Lakes versus Cowan case in 2019. Here we have an association where the association won the battle but lost the war. Pursuant to the restrictive covenants, CC&Rs, the owners of lots had to comply both with the CC&Rs as well as the county ordinances. The county ordinances required a certain setback in order to construct any improvements. The setback was 10 feet, and the evidence as best the court had in front of them was a testimony of one of the owners that the garage constructed was 5 feet from the fence. So the assumption that the court had to make was that the fence represented the actual legal boundary Unfortunately, on both sides, they didn't present a survey from a licensed surveyor in the state of Utah. So it was disputable, or could have been disputed, as to whether the property line was where the fence was or not. At any rate, the garage was constructed within 5 feet of the fence, not 10 feet as required by the county ordinances. An interesting situation that comes up in associations is the CCNRs may not be precise on enforcement or the ability of the HOA to enforce county ordinances as part of the CCNRs. In this situation, it was unclear. There was an agreement with the developer that in the event the HOA failed to enforce the CCNRs, the county could enforce the CCNRs, but it wasn't entirely reciprocal. So we have the garage being constructed in violation of the county setback lines, but there was no express covenant within the CCNRs other than construction should comply with county ordinances. The county did approve of the construction. The neighbors got mad and said, this is a violation of the CCNRs, vis-a-vis, it's a violation of county ordinance. The association sought to enforce the county ordinance and sought an injunction to prohibit the owners from constructing the garage. Initially, this started out at the foundation of the garage. At the final stages, the garage was mostly constructed. The roof was the only remaining part of the garage to be constructed. The court went into analysis on the circumstances under which an association is entitled to an injunction, meaning that the court could order the lot owners to cease construction or to remove the construction to make sure that it complies with the ordinances. In this situation, although there was that agreement with the county, the court found that the county did not assign any rights for the association to enforce the county ordinances against the lot owners, and the lot owner did not show irreparable harm that cannot be compensated by monetary damages. A few more facts on this situation. There is an easement for a proposed road that has not been constructed by the HOA. They anticipated in the future at some point, unknown, the road may be constructed, but this garage constructed by the lot owners would infringe or encroach upon the easement for that road. In the end, as the court stated in quotes at the top of the slide, the association won the battle but lost the war. They didn't obtain the injunction because they were unable to show or didn't present any evidence as to irreparable harm, meaning that the harm can't be cured by monetary compensation. So a note on that one, look at your CCNRs. If you're trying to enforce a county or city or municipal ordinance, there needs to be express authority assigned from that municipal, county, or cities in order to enforce such ordinance. So a lot of
another question.
Go ahead.
I was going to say another question at ACC related, not quite with municipal ordinances, maybe with the previous case. In an HOA under developer control, can the ACC approve building changes that go directly against the design code without first amending the design code?
Excellent question. Oftentimes in the CCNRs that I've reviewed, the developer is expressly has covenants in there exempting the developer from ACC approval, or the ACC is controlled by the developer. Assuming that the ACC is exempt in that situation, and again, we'd have to look at the governing documents, the developer may develop in a manner that is not strictly in compliance with the CCNRs during the developer control period. Thereafter, Once the developer turnover happens, then it's up to the ACC, and you would have to completely go against a restriction in the CCNRs. There would have to be an amendment of the governing documents.
Hey, Carson, can I chime in on that?
Sure.
So, Scott, will you read the question one more time?
In an HOA under developer control, can the ACC approve building changes that go directly against the design code without first amending the design code?
Okay. Well, the other take that I have on that, to piggyback on what Carson said, is, you know, the developer is probably going to have unilateral authority to amend the CCNRs. And then typically, if their documents are written properly for, you know, representing the developer, they will also exempt themselves from the rule making requirements in that 15-day period. So if the developer is still in control, and they want to avoid somebody trying to bring a claim saying they didn't have that authority, they can easily just amend their architectural control guidelines, right? And because they have that authority, and then if necessary, if those design guidelines are in the declaration and they have the authority to unilaterally amend, then do an amendment to make sure that it's conforming with what they're building. So, you know, it's always, then that way, if they're making those changes, then you avoid it where owners may say, hey, you don't have this authority, we're going to challenge it. And so you put a little bit of money into just updating the documents and avoid it escalating to litigation.
Thanks, Glenn. All right, we'll see if we can move to the next slide. Bell Canyon Acres HOA versus McClelland, 2019 Utah Supreme Court case. This is a situation where we have a bridle path, and as the Utah Supreme Court has stated, for those not familiar with horse and equestrian activities, a bridle path is a path for horses to be ridden. There's an express easement through the association that provides for a bridle path. The HOA, through the years, decided that certain owners within the association that had lots adjacent to the bridle path had encroached upon the bridle path easement. And to start off the case, the Utah Supreme Court stated, good fences, it appears, stop making good neighbors right about where they start to encroach on bridle paths. So don't encroach on a bridle path. The association brings a lawsuit against certain owners, but not all of the owners of property, owners of lots that were adjacent to the bridle paths. Motions were made in the court to dismiss the action because they didn't name all of the owners who had lots adjacent to the bridle paths. This was a declaratory action where the association simply sought to have the court declare that those owners that were allegedly encroaching on the bridle path were in violation of the CCNRs and therefore should be enjoined from further violating the bridle path. So not all of the owners were named in the HOA. Strategically, the motions were made to try to dismiss the case for failure to name all of the parties. The court ultimately came down and said the case is binding. This case can move forward and is binding only on those who are named parties. In other words, if they didn't name the owner of lot 4 in the case, that it would have no precedent or prejudice against that owner because they weren't named and didn't have their day in court to defend against the alleged violations. So it's important in the sense of if there's 1 or 2 or 4 or 5 owners that are in violation, you don't have to name every owner, only those who you find that are in violation of the restrictive covenant. Next, we get to a fun question, probably or a fun case. Probably time for some more of the poll questions here. To start it off, you can see an image in front of you. There's a public roadway, a park strip, then a sidewalk, and then grass to the left. The association has common area owned by the association. Then the city or municipality owns the remainder of the park strip. The park strip has an iron rod or some type of metal rod that is sticking up. A person is walking and runs into the metal rod, not on association property, trips and falls and is injured, brings a lawsuit against the city, the HOA, as well as the community management company for the HOA. So going to the poll questions, who thinks that the HOA and the HOA's community management company is liable for the metal rod sticking up in the parking strip that caused or allegedly caused the plaintiff to fall and be injured? Go ahead and pull that.
Which one was that question?
Pull the.
Which one was that?
1 through, let's see. No, I can't. Okay. Okay, maybe it's not in a poll. That was number 7 and 8. So we won't pull that question. But all of you can think to yourselves, is the HOA or the HOA community management company liable for a metal rod that is sticking up and causes someone to trip in a park strip that is not part of the HOA property? This is a recent 2020 case, and we'll pull the next slide on premises liability. Also, one thing to note, Harriman City Ordinance requires that the HOA or the owner of the adjacent property to park strips has a duty to maintain the park strips. In this situation, there weren't facts in front of the court to determine whether the city actually enforced that or if the city assumed maintenance of this park strip despite the ordinance. This goes to trial, and the defendants, being the Rosecrest HOA and the Community Management Company, filed a motion, and a successful motion, to be dismissed from the lawsuit. Then the plaintiff takes it up on appeal, goes to the Utah Supreme Court, and the Utah Supreme Court came down and said, trial court, you got it wrong. In dismissing the HOA and the management company for the HOA, the Utah Supreme Court went into an analysis as to the facts, because this was won on summary judgment at the trial court level. And the analysis consisted of whether the metal rod showed a durable, non-transitory, and rusted condition such that a jury, not a judge, had a duty or was able to infer from the facts whether there was a duty of the HOA and the management company to warn any bystanders on the adjacent property. So this is a treacherous case for all HOAs, to be aware of not only the ordinances of the city as to maintenance of the surrounding property, whose duty that is, and whether there's a duty to warn. Was the metal rebar or spike sticking up sufficient that the HOA or the management company should have known of it, been aware of it, and notified others to make sure that the metal stake was removed. So it's very fact intense here as to what the duties are, but as an HOA and a director or board member on HOAs, beware of the surrounding property and any hazards or known dangers, and whether or not you have a duty to at least report to the city to have them come and remove it, even if the HOA is not managing that property. Next, we have.
This is interesting because the city owned the park strip, but the HOA mowed it. And so I think Carson brings up a great point of, hey, that last point on the last slide, by city ordinance, the HOA was to maintain that. And so you, as board members and as associations, you need to be aware of adjacent property that you may be, even though you don't own it, you may be required to maintain it. So that's kind of where this one landed.
Right. It's really, most of us go by the theory of not my property, not my problem. Here's a case where not my property, it was a city property, but the court said it is an issue of material fact for a jury to determine whether it is an HOA or a management company problem to report and have remedied before somebody gets injured. So the next case, Utah Supreme Court case, we've never heard of High Country Estates Homeowners Association in litigation in Utah. I think there are a few published cases with High Country Estates. In this situation, WDIS is a group of homeowners or lot owners that got together, filed a lawsuit requesting that the court declare that these certain lots were not encumbered by the restrictions and covenants. So common in HOAs where certain members say for whatever reason their lot isn't subject to the CC&Rs. The trial court and kind of the basis of the arguments of the WDIS group were that there were certain procedures that weren't followed with the articles of incorporation and bylaws or other governing documents of the association. So it goes to the trial court, and the trial court said, hey, these actions in relation to the governing documents not being properly amended, adopted, or recorded are subject to statute of limitations, and the statute of limitations to bring those causes of action have passed. Therefore, the entire action shall be dismissed. On appeal, the Court of Appeals comes back and says, this is a true quiet title action because you're seeking declaration from the court that the restrictions and covenants don't apply to these particular lots. And the Court of Appeals said, if the party's claim for quiet title relief can be granted only if the party succeeds on another claim, then the statute of limitations applicable to the other claim will apply to the quiet title, meaning that if the only way you can prevail on quiet title is by succeeding on these other claims, then the statute of limitations applies. Otherwise, under quiet title actions where you're trying to clear title and have the court declare that the covenants or encumbrances do not impact the lots, the statute of limitations do not apply. So a situation where is the case a true quiet title where we're trying to have the court declare that the restrictive covenants do or do not apply, versus a case where you're trying to circumvent matters and the quiet title action relies entirely upon another cause of action that would have an applicable statute of limitations. All right. Next case, Thompson versus Kapner. This is another enforceability of restrictive covenants. In this situation, you have lot owners within a subdivision that after the subdivision is platted, the lot owners decide to adopt restrictive covenants. So this is another procedural case where you need to make sure the procedures are properly followed. In this situation, there's spouses that own the lot. One of the spouses signs the restrictive covenants. The other spouse does not sign the restrictive covenants. Later, it goes to court whether or not the restrictive covenants are applicable to the lot that was subsequently subdivided. And restrictive covenants were not signed by both spouses. Although the plat and other documents were signed by both spouses, the plat and the other documents signed by both spouses didn't clearly refer to the restrictive covenants. The court came down and found that the spouse was not an agent for the other, which, oftentimes there's cases that find one person signing is sufficient for both persons signing because of the principal agent relationship. In this situation, the court found the spouse who signed on the restrictive covenants was not an agent for the other spouse, and thus it required both spouses to sign on to the restrictive covenants. Therefore, the restrictive covenants were not enforceable against the lots, one lot subdivided into two lots within this subdivision. The next case is a relatively new Utah case from the Court of Appeals regarding easements in the plat and or the CC&Rs. And I think we have a question on this one, Scott. If we do the poll before we go through the presentation, question number 3.
3?
Yeah, let's run through question.
Okay. So the question is a little long, so let me read it for you because it only got the first part of it. But we're going to go ahead and launch it. A court may interpret east to west in a legal description of an easement contained in CC&Rs if that's the only logical way. Is that the only logical way for the legal description to connect the boundaries? True or false? So, is easement is defined in the CC&Rs. Is that the only logical way for legal description to connect the boundaries? Is east to west? True or false?
So I'll give you a little more context on this question. The easement described in the CC&R is the only way that it would connect legally was to reverse one word, making east to mean west. That way the legal description of the easement would connect, and well, there were a few other errors in the legal description as well. But can a court go and interpret a document that expressly states east to expressly state west, or to mean west in the legal description of the easement? So true or false?
Okay, thank you. Looks like we got everybody. We can go ahead and close that poll and see what people have voted. Dun, 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 dun. Here we go. So 55% came back false, 45% said true.
Okay.
Person, what say you?
What say you?
Or what says the case?
Let's walk through it. Good. What says the case? So in the first image, and this is a situation, again, underlying facts you have to pay attention to. There was a plat long before the March 2006 plat, but you can see in the image on your screen, in the 2006 plat, the special use area was described as the shaded area. Later, there are plats recorded amending and CC&Rs that also amend this special use area. Initially, and to me, throughout the case, you can see the owners intended to have an easement so that you could access the Provo River. As you look in the left part of your screen, this windy line is the Provo River, allowing people with horses to cross Lot 2 and access the river. Later, a subsequent owner buys Lot 2, looks into the legals and says, no, the legal description in the CC&Rs that had what one party would call Scrivener errors and another party would just call a botched legal description, that easement was cut off right here, looking at the right side of the screen. So you're basically cut off right here and you don't have access to the Provo River and beyond. The Court of Appeals, in reviewing the information submitted to the court, found that the botched legal description in the amended CC&Rs was not unambiguous. East cannot mean west. So therefore, the answer to the question would be false. The legal description, if there is an error, it can't be interpreted based on the plain language, and the court remanded back to the trial court to take additional evidence as to what the proper interpretation of the easement is. So a note on this one, many times associations amend their CC&Rs and they may not have a surveyor or licensed surveyor or other professional review the legal description of easements within the CC&Rs, and a mere reference to the plat, if the plat is incorrect, would not work. So take away from this, if there are easements that are only described in your CC&Rs and not in your plat, and you're amending the CC&Rs, you should have a professional check the legal description to make sure that the lines connect. In this situation, east does not mean west. There was also some distances that the trial court thought, hey, this is the only logical way that this easement could exist, and therefore I'm going to run with, Scrivener's error within the legal description. And the Court of Appeals said, shame on you, trial court. You need to hear both sides and take in extrinsic evidence to determine what the easement consisted of and where it started, where it ended. Okay. Next one.
Perfect.
Now, break.
Thank you, sir. So, but I'm not going to let you off the hook quite that easy yet, Carson, because we've officially teased the audience. They all want to know the answer to our first poll question. In times of COVID, can the board pass a rule via email?
Excellent question. Thanks for not letting me off the hook here, Scott, and audience. In times of COVID, everything's allowed, right? We can mask up and stay in our houses. And if we're susceptible to COVID, then we can receive all sorts of accommodations. If you live in Texas, in the case that this question is in reference to, the person had a pathway where the public could walk by the backyard. The person also had a high susceptibility to COVID and requested that they be allowed to erect a fence to block off the pathway from the owner's backyard so that the owner could enjoy the backyard as well as sunlight and fresh air, which, hey, I can't blame them. I enjoy my backyard and fresh air. In this situation, the applicant or the person requesting the accommodation had medical reasons. They'd been undergoing chemotherapy for cancer, and so they were highly susceptible, but the court found that does not constitute a handicap under the acts that would allow for a reasonable accommodation request. So if you're in Texas, being susceptible or highly susceptible to COVID doesn't allow you to assert a right for a reasonable accommodation to waive architectural requests. That situation hasn't been, obviously litigation takes a while to get through courts, so there are many states where it hasn't been stated whether or not it's considered a handicap. Some of the commentary from the CAI presenter on this case was that if you live in California, it may be more likely that California would consider this as a handicap, and therefore the HOA must grant the reasonable accommodation if it's truly found to be reasonable. In Utah, I'm unaware of any such case where high susceptibility to COVID-19 would be considered a handicap such that it warrants a reasonable accommodation. So in Texas, that was upheld with the association denying the request for a fence to separate the public pathway from the backyard.
Perfect. Thanks, sir. All right, now we're going to have a word from one of our great sponsors, Straight Stripe. If you have need of asphalt work in any of your communities, please consider them. They provided a brief commercial for us, so hold on. Here you go. Hopefully this works. Doesn't sound. There we go. So if you have any need for asphalt work in your communities, please consider Straight Stripe. They're a great sponsor, great partner of the chapter here, and make these educational events possible. All right, give a little bit of break. Now we're going to jump back into it, and I think Quinn, my friend, you're taking over. Is that true?
Yes. Thanks, Scott and Carson. Carson, we didn't talk about this before, but I find it interesting as you're going through all that case law, and I'm looking at that, realizing that, I either currently represent or have done legal work for, I think, all but two of the people in those cases. So,
is that a good or a bad thing?
Depends on the particular matter there. So, but as you were going through them, I'm just visualizing in my mind these specific HOAs and some of the issues that were there. So, interesting. Okay, well, I'm going to be covering the legislative updates for this evening, both the ones that bills that were discussed and passed at this last legislative session, and then later on I'll talk about the bills that did not pass, we anticipate may be introduced next year, and also some potential future legislation that may come up. So the first one I want to talk about has to deal with our COVID climate. I'll go through these. These are the ones that passed, so these are the ones we'll be discussing. Bill that talks about using reserve funds during emergency. That was precipitated by COVID. Accessory dwelling units, security cameras, amendments to remove discriminatory language in recorded documents, impact fees, building inspections, rental disclosures. And then the ones that did not pass, which we will discuss at the end. It's not advancing for me.
There's slight delay.
There we go. Okay. Short-term rentals, required information on recorded documents, resident lien recovery fund, and open meetings. As we talk about the required information on recorded documents, I want you to keep in mind that Equine Holdings case that Carson just talked about. Okay, I'm trying to advance it again. All right, hopefully the slides catch up. I'll just start going. This first one, it's SB 75. This is, it was introduced because of COVID. It amends sections in both the Condominium Ownership Act and the Community Association Act. Essentially what it does is it provides the ability for the board to use reserve funds in a declared emergency. It has to be statewide. you know, as we look at a year ago, as we went into lockdown, there were a lot of concerns of what would be happening with the associations and their finances. Would people be paying their assessments, or would there be a big shortfall in the budget? How could they cut back on certain expenses? Would they have to special assess owners? And could they use reserves? Prior to this bill passing, still has to be signed by the governor, but it said that the association could use reserve funds if there was a vote of the owners for a specific purpose that other than what the reserve was intended for or initially set aside for. So what this new statute does is, in the event of a declared emergency, then it grants the board the authority to use the reserve funds if there is a budget shortfall. And so it includes in the statute certain situations that address a budget shortfall, and then talks about that your reserve funds, you can put them aside, not just for the future expenses to maintain the common area, you know, and do those improvements later on, but also for the purpose of addressing any budget shortfall. So what it does is the statute says a shortfall can come about, again, when there's a declared state of emergency for the entire state of Utah, and then you have to have at least 10% of the owners who are not members of the board that they are delinquent as a result of the emergency. So you have to meet those different qualifications. And then the owners still have the authority to veto that. So if the board decides they want to use the reserve funds, the owners can get together and with a majority vote, 51% of the allocated interest, they can veto that action at a special meeting. The next one is House Bill 82. This deals with the single-family housing modifications or for accessory dwelling units. Hopefully the slides catch up here. But this is, it's going to amend the Community Association Act as well as the Land Use Development Management Act for both the cities and county. Let's see, Scott, are you able to advance that? See if it works better on your end. There we go. Okay. So what it does is oh, now we went too far. It first of all defines what is a dwelling unit. Go back one more. So it's defining what is a primary dwelling unit. It has to be a single family, and for things, for purposes of addressing us in an HOA, it has to be detached. So that's meaning it's not going to be applying to condominiums or townhomes that are attached products. And then it has to be occupied as the primary residence of the record title owner. Then an internal dwelling unit or an accessory dwelling unit is a separate unit within that primary dwelling. It has to be created within the footprint of the dwelling, meaning they can't do an extension or an expansion of the home in order to create the accessory dwelling unit. And it has to be created for the purpose of a long-term rental, so at least 30 days. This statute would restrict an association from adopting rules or provisions that would prevent owners from having an accessory dwelling unit, as long as that unit would comply with the land use ordinance, building codes, health code, and the fire code. And it's also doing the same thing for the city's authorities, where they cannot adopt certain ordinances to prevent these, although there are some exceptions to that, as we'll talk about here in just a second. So associations can also not adopt a rule or provision in their recorded covenants that prohibits the creation of an accessory dwelling unit. So owners, they have the right to create an accessory dwelling unit, and as long as it's complying with all of the respectable codes, they can have it, and we cannot restrict that. The municipalities do have some authority to restrict, and this bill, I also sit on a policy legislative committee for the Utah League of Cities and Towns, And so we had a lot of discussion about this, how this is taking local authority away from the municipalities. And so there was a lot of pushback from the cities and towns in the state. And so there were some changes which did allow for them to still create some zoning restrictions or limitations, but they cannot restrict the zoning for accessory dwelling units in more than 25% of the total residential areas within the municipality. They can restrict, do certain restrictions around college campuses. And the big thing for us that helped as well, not only that it had to be a detached product, but it also puts it has to be at least 6,000 square feet. So that's great. I mean, many of the communities that we have would not have homes that big. So it really would limit where it could be. The municipality can require that these not be used for short-term rentals, Airbnbs, and require that they be owner occupied, and also that the owner have a business license or a permit in order to operate the accessory dwelling unit as a rental. Next one is Senate Bill 31. This also amends we got the wrong citation there. It amends the Condominium Ownership Act and the Community Association Act. Little background on this: it comes out of a tragedy. It's too bad, where a woman was in an HOA visiting a family member. As she left the home and apparently was going back to her car, she was murdered, which is terrible. And as the police were trying to find leads, they were talking to neighbors to see if anybody had cameras or doorbell cameras, whatever it is, to try to find video evidence of anybody in the area. They did not have any, because that community association had a rule that they could not put those on the exterior of the buildings because that was common area. And so what this bill does is it makes it so a community association cannot prohibit the installation of security cameras or doorbell cameras in an area that's adjacent to the entryway, so the door, to a window, or any other outside entry point to the unit. They also they can restrict it to the common area that's not physically connected to the unit, but the common area that is directly adjacent to the unit, so usually the exterior of that building, the owners could be installing the security cameras or doorbell cameras. And so even though an association cannot restrict the installation, recommendation is that the association begin adopting rules that specifically address maintenance issues or liability issues. One of the main concerns is as people start to put holes in the exterior of the building, especially an attached product, what happens with water penetration? If they're not sealing the installation points, you'll get some water in there, and that can really wreak havoc. Scott, you've been involved in some of those construction defect cases. You can probably attest to what water can really do, and maybe some of the others who are here. And so again, adopt some rules really addressing, yes, they're allowed to install them, but have some things in place of where they have to take precautions to make sure they're sealed correctly. The next one, I think this one is great, where this is, it amends the statute allowing the board to file an amendment to remove certain discriminatory language in existing recorded documents. So this is discriminatory language that addresses race, color, religion, sex, national origin, familial status, source of income, disability, sexual orientation, and gender identity. Many of you, as you've been around, you may have seen some of these covenants that have discriminatory language. I know years ago we had one in a cabin community here on the Wasatch Front that had some language in there that you could not sell the property to people of a particular race. And even though you could not enforce that under the law, it was still there, and the community wanted to amend that, and their documents required 100% approval. And so we did get the law changed at that point to bring that down to only requiring 67% of the owners. So we were able to take that out. And I think this is great where you don't even need to go to a vote of the owners where you can take it out. And so we'll talk about that procedure in just a moment. But what you can do is if it's in a covenant-bound neighborhood or a non-community association document, then the owner of the property can go and record a document with the county recorder that has this language. So this is the language actually set forth in the statute that an owner of the property would do that and record it with the county recorder and to specifically identify the language that is illegal. Not only quoting that language, but they can go in and specifically quote the language that is stated in there as being void. And this is one I think it's great timing. Once the governor signs it, I have somebody up here that actually made the local news where she was unaware that she had recorded covenants and that were recorded back in the 40s and has some discriminatory language. So once this goes into effect, I know she'll be taking advantage of that. If the discriminatory language is in recorded covenants for a community association, then what has to happen is the owner can make a request to the association that the language be removed. The board then has 90 days to investigate the owner's request and make a determination whether or not the language is discriminatory or not. If it is discriminatory, then the board, just by a majority vote, can adopt an amendment and record that with the county recorder to remove that provision with the discriminatory language. And so, I think that's great, so that they don't have to go through the process of requiring all the owners' approval, the mortgagee approval. And then what it also did is to promote the removal of this discriminatory language. It removes the bar for the financial issue of the county recorder should not be charging fees, recording fees for these types of amendments. I want to see how that is actually received by the county recorder and whether or not that's requiring them to reverse it, because I know as we file electronically, it's just automatic, they charge you, but we'll see how that's actually put into practice as those things are recorded. The next one, House Bill 63. This only impacts us in the community association moderately. It amends the Land Use Development Management Act, and what it does is it modifies the calculation for determining impact fees, and really puts in that certain overhead expenses can now be included in that calculation, such as doing some impact fee analysis or an impact fee plan by these government entities or quasi-government entities when they make a determination of how much they should be charging as an impact fee. And so the practical effect of this law is allowing these municipalities to include these additional expenses into their impact fee analysis. That's going to justify increasing the amount of the impact fees that must be paid by developers, which then gets passed on, as we know, as they're doing building, it really just gets passed on to the end buyer. So that could, even though it may be slight, could see an increase in expenses for home building. The next one is another one that really deals with developers. This is one, again, that the municipalities were not pleased with as it came up. This one and the accessory dwelling unit were two of the most hotly contested with them in the legislative session this year. What this does is, developers and I guess anybody who's building a home can often get frustrated when they're trying to get things approved through the local municipality and getting the buildings inspected, getting a certificate of occupancy, because if the municipalities are overwhelmed, it's just being dragged out. So this puts in certain provisions and circumstances where if the developer is making a request and it's taking too long by that municipality, the developer can then go out and engage a third-party inspector to come in and do the building inspection, and in certain circumstances even issue the certificate of occupancy. So the The main concerns here is the municipalities are concerned that this removes their local authority of those inspections. It can increase the turnaround time because it's going to push those municipalities to be quicker on those reviewing the plans and getting the inspections done. But there is concerns if the municipality really is overwhelmed and inundated with these plans and reviews and inspections, they may not be able to get around to them. And so developers will go out, hire these third parties, and they're kind of the hired guns, right? I mean, they want to make the client that's hiring them happy, and so they may be a little lenient on some of the inspections. You hope not, but that can happen. And so what that could be is that going to result in a decrease in the quality of the housing products, which many of us view that sometimes that can already be a pretty low standard in some of the housing projects. So if that goes down, that's a concern. The last one that I've got here in the legislation that passed deals with rental expense disclosure requirements. Scott, you may need to advance that. It's not working for me again. Again, this doesn't impact too much for community associations, but as I know, we've got managers who are also managing some rental properties. And so what this does is it's requiring owners or landlords of the property to disclose to prospective buyers. Can you get that to advance there, Scott? I'll keep going. You'll pull it up. So now when they're presenting these prospective buyers with what it's going to cost as their rental, it's not just the agreement of here's the amount of your rent. They also have to provide a good faith estimate of, yes, the rental amount, but then they also have to include the estimate of what the amount of the fixed expenses, the non-rent expenses would be in that rental agreement. So that can be, they're paying for cable. In an HOA, if the renter is going to be responsible or paying the assessments to the association, they need to include that. They also need to be disclosing the use-based or non-rent expenses as part of that. So that use-based, it can be variable. That can be your gas, electricity, water, those types of amounts. Is it still not working for you either?
No, it's not. It's showing that it's moving, but it's not working. But we'll get it. We'll figure it out.
All right, I'll keep going. And then they also have to disclose the criteria for how they're going to be determining eligibility for the renter, excuse me. And so they have to be disclosing them. We're going to be looking at your criminal history, not your credit, your income, employment, rental history. And so, that can really add to the amount of work that these landlords have to do up front. May scare away some of the prospective renters. But the policy is they're trying to avoid these situations where renters get in, they think I only have to pay this much in rent, and then they're surprised with these additional expenses, and then they cannot make the rental payment, and then they get evicted. So by disclosing it all up front, it is good for the landlords where they should be getting renters in there that can afford to live there. And the disclosures can be done in the rental application, in the deposit agreement, or some other written summary. And so landlords should be able to just create that document and hand it out at the time that somebody's coming. They do have provisions where the prospective renter can get the money back if they follow the certain procedure. And then the other thing that it does is it puts a limit on the amount that a landlord can charge for a late fee. It caps it at 10% of the rent or $75, whichever is greater. And then something that's really going to apply, especially for you property managers that have clients with rental properties in a community association, it requires that, or it states that the landlord or owner cannot be charging a fee, a fine, assessment, or interest, or any other cost that's greater than the amount that is set forth in the agreement and that good faith estimate, unless it's on a month-to-month lease, rental, and they give them 15 days notice of the charge that's going to be made. So you want to make sure that any of those rental agreements go back and are specifically identifying that if those tenants engage in some action which results in a fine, a violation of the community association's governing documents, and a fine is imposed, the landlords want to be sure that they have the language in their rental agreement that they can pass that through to the renter. Also, if the renter is paying the assessments, again, they want that language in there. So those are some tips for the laws that just passed. We're waiting for the governor to sign them. We're passing it back over to Carson to do some national case update. There's the rental expense disclosures.
All right. Before we do that, we got another word from one of our fantastic sponsors. So this time, give us just a second here. Fingers crossed this works. But here we go. Give me just a second here. Perfect. Okay. Thank you to Luke Udy and Associates for sponsoring this event. Again, they're one of the fantastic partners. If you have insurance needs, please reach out to them, and they'll be happy to hook you up. All right. So we're going to do another poll to get us started to set off right before we get going here. And all right, here we go. A member of the board of directors is liable, let me read this again, is not liable for the HOA's refusal to grant a request for reasonable accommodation. True or false? Again, a member of the board of directors for an HOA is not liable for the HOA's refusal to grant a request for reasonable accommodation.
So in other words, if you're a member of the board and you get a request from a lot owner for a reasonable accommodation under federal law, and you refuse to grant that reasonable accommodation, and later a court determines that the request was reasonable, and can you as an individual board member be liable to the person who was denied the reasonable accommodation request? So HOA liability.
Okay, looks like got a couple of we're going to go ahead and close down the poll and see how the responses work. Okay, so we have 9% say true, 82% say false, 9% say it's uncertain. So, Carson, what says the case, or what says you?
We'll get into that, but it's good to see a 9-9 split and 82 saying it's false. So a bunch of false doctrine. The other thing, Scott, warm back up. It's been a minute, and I'll try to go through this a little bit quicker, but I have to warm my voice up. So what you didn't know is you and I are going to have a contest on tongue twisters. So you ready to go? Betty bought butter, but she said this butter's bitter. If I put it in my batter, it will make my batter bitter. So does Betty bought a bit of better butter, put it in a bitter batter, made her bitter batter better. Okay, now that my voice is warmed up, let's go to the national cases, the HOA trend. And then we'll let Scott practice in the meantime, and we'll have a contest to see who can do Betty Butter quicker and better.
Just concede, Scott.
All right. U3 versus Equity Experts Organization. This is a Georgia case where the peaches are great. You have recorded covenants or CC&Rs that provide for interest on delinquent accounts. So one of the, as all associations know, the blood life to the association is assessments and the ability to collect assessment. In this association, the CC&Rs allow that the association can charge for interest on any assessments that are past due. The association enters into a contract with a collection agency, not an attorney or law firm office, but a collection agency. And in that, the collection agency has a schedule of fees as to how much will be charged for each step in the process of collecting the delinquent assessments. The fees are published, but the CC&Rs do not expressly identify the fees or identify that the collection agency, if an account is turned over to the collection agency, that they can collect that amount of fees. This gets challenged in Georgia, and the plaintiffs are able to have the lawsuit certified as a class action, so not just the individual owners that the collection agency went after, but also that those plaintiffs could be representative of the other persons whom the collection agency went after for delinquent assessments. Here's the takeaways, as you can see from the great picture: hear no evil, see no evil, speak no evil. The importance to HOAs would be look at your governing documents. Do the governing documents allow you to collect collection agency fees or enter into an agreement with a management company or collection agency and allow the collection agency or management company to charge certain fees when the accounts are delinquent? If those provisions are not expressed in the CC&Rs, a recommendation would be to amend the governing documents to allow for third-party charges such as management company fees or collection agency fees. Spinning through to the next one, we have Deerbrook South HOA versus the Battles. This is a Florida case. The HOA pursued judicial lien foreclosure for unpaid assessments. During the process, some amounts that were sought to be collected had expired under the statute of limitations in Florida. In the lawsuit, the owners didn't assert as a defense that the statute of limitations barred collection of those outstanding assessments that were beyond the statute of limitations. The court found because the owners did not assert that defense, they weren't entitled to the defense. Part of a basic pleading requirement is that you have to set forth your defenses, one of which would be that the collection of the assessments were barred in part or in full by the statute of limitations. As to Utah and the participants in this webinar, what is the collection policy to pursue delinquencies? Is there a limitation on how far back you can go? How long can you wait before you, as an association, try to collect the assessments? And in this situation, waiting years could be costly. However, in Florida, because the owners failed to assert the defense, the court upheld pursuit of the entire delinquent assessments, even if they were barred by statute of limitations. In Utah, for your information, there is a 6-year statute of limitation on breach of written contract claims, which would likely be what would govern in a case of a Utah HOA pursuing assessments or collection of delinquent assessments. That statute of limitations is, however, told if the debtor files for bankruptcy. Moving on to the next one, we have a South Carolina case, Winrose HOA versus Hell. In this situation, the HOA pursued again judicial foreclosure and obtained default judgment against the homeowner. An interesting fact, during the proceedings, the homeowner did receive a notice and demand to pay and did in fact pay the assessments, which I believe were $250. Received something from the management company or the board saying that that satisfies the assessment. However, there was miscommunication in this case. The HOA continued to pursue the delinquent assessments, unbeknownst to the owners who thought, hey, we received notice from the association or whomever that we were paid in full. This goes all the way to foreclosure. At the foreclosure, the person at the courthouse steps or wherever the sale was held paid $3,000 for the property. The owners had been paying on a mortgage for several years and had at least $60,000 in equity in the home. So this was one heck of a deal for the person that purchased at the foreclosure sale. The defendants later learned of the foreclosure when the investor who bought at the foreclosure sale tried to evict the owners. And the owner said, we thought we had paid this. The owners then filed litigation and pursued to have the default judgment and the foreclosure sale set aside. In this situation, the court exercised its discretion and found that the $3,000 purchase price by the investor was so grossly inadequate that it shocks the conscience of the court and cannot be sustained. So the takeaways from this case, number one, once an account is turned over for collections, have a single point of contact. If you turn it over to a collection agency or your management company or a law firm is handling the collections, if there are any inquiries directed to you as a member of the board or manager, make sure that you forward them to the proper point of contact so there's not miscommunication and later litigation where things get overturned. Any statements to owners should include a disclaimer about additional legal fees. As we all know, once it hits the legal process for collections, fees add up as we mail additional letters and demands, file lawsuits, or record liens and pursue non-judicial or judicial foreclosure. As another note, give proper notice to the owner and other interested parties. The last thing we want to do is hit the news as we're the ones who foreclosed on what started out as $250 in delinquent fees, ended up selling the house for $3,000 and circumvented the owner's equity of $60,000. The goal is to collect the outstanding assessments, but not to break the homeowner. What is the fair market value of the home in consideration of the deficiency or the amounts outstanding? And also under Utah code, when there is a lien that gets foreclosed on, there's a statute regarding pursuing deficiencies. If a lot is sold at a foreclosure, non-judicial or judicial, the remedy left is that you pursue a deficiency judgment against the debtor to collect the remaining amounts if you're unable to collect those at the sale. Next case, Ashton Round.
Carson, can I interrupt real quick?
Yes.
So I want to make share a little story on that last slide where it was talking about having the importance of having a single point of contact once somebody's turned over to collections. So this was not with me, but it was another attorney with whom I worked with at the time. He was doing collections on a delinquent HOA account. And what happened was he was on the phone with one of the owners, and then his assistant came in and said, hey, you're on the phone with so-and-so. I've got the manager on the phone who wants to talk about that account. And so he put the owner on hold, went to talk to the manager. The spouse of the person that was talking to the attorney was calling the management company at that time. And so both spouses were calling the attorney and the management company, trying to see who could get the better deal, right, to pay off the account. And so they're both on the phone, and the manager talks to the attorney, and they figure out what's going on. And so that happens. I'm sure we've all been there where they want to find where's the weak point, right? We're going to go talk to the board members. We're going to talk to the manager. We're going to talk to the law firm. Who is going to give us the better discount or deal? And really for us, we just want to put forth a unified front. I'm not saying you can't, provide discounts depending on certain situations, whatever it is. We just want to have a single point of contact so that, we keep everything consistent with what we're saying.
Good point. And it happens very frequently. The easy response is to that is if an account is turned over to collections via the management company or a law firm, if you get an inquiry about it, make sure that you direct the inquiry to the person who holds the account, because you don't know what documents have been recorded, liens, et cetera, to give a true payoff in that situation. Okay, Ashton Ranch Community Association versus Jones. This is Arizona, so fairly close to Utah. The HOA completes a foreclosure. There are excess funds at the foreclosure, 37,000 in excess funds. Liens and interest are terminated by the foreclosure and then attached to the excess funds that get deposited into the court. The purchaser of the property at the foreclosure sale and the prior owner file claims for the excess funds, saying, hey, the purchaser says, I'm entitled to this. The prior owner says, no, I'm entitled to the excess funds. So it becomes a battle of priority. Who has priority in this situation? The prior owner, in this case, was entitled to the funds. So some takeaways from this. Again, look at Utah Code 57-129 on disposition of proceeds after a foreclosure sale. Junior lien holders first, and then the homeowner, although you have to take into consideration the homestead exemption. Question for Quinn here. If the HOA completed a foreclosure of its lien, but there was no excess funds, a superior lien holder subsequently foreclosed on its lien, and then there was excess funds. So we have the HOA who is junior to a bank. The HOA doesn't get satisfied in the entirety. Then you have the bank who forecloses. Where do the excess funds go? And Quinn,
good question. So I had this one where representing the HOA, we did foreclose on a property, and then they had it as a rental property for a while, and then the superior lien holder came and foreclosed, and there were excess funds. What happened is the owner of the property had died, and so it was tied up in with the estate for a while. And so we did, both us and the heirs of this individual filed claims with the court to try to find out, hey, who's it entitled to? Our position for the HOA is once we foreclosed, we became the legal title owner of the property. And so we are the owner for purposes of if there's excess funds, it goes back to the owner. Obviously, the heirs were arguing that, no, this is, it really applies to who had it with the lien holder who foreclosed, and that individual who had it for years to reap the benefit of the equity. And we did not get the answer to that question because after oral argument, the judge took it under advisement, and then the HOA and the heirs ended up reaching a settlement agreement on how to split the excess funds. But it is a question I'd like to know the answer to. I mean, it's not. When you just look at the statute, they're not addressing this situation where you've got the multiple foreclosures that take place and who gets those excess funds. I think you've got the legal argument to say the HOA should have had it. Maybe an equitable, or if you look at it just in fairness, it would go to the to the heirs. But it always made me think, well, what if the HOA would have just filed a quiet title action and then sold the property, right? They would get all of the upside to that sale. And so if they could get it in that instance, why can't they get it when there's the excess funds proceeds? But again, that's one of those questions that we'll have to wait to get answered when it comes up again.
It's like a law school exam, getting to maybe.
You argue both sides.
All right. Okay, next one, Williams versus Salt Springs Resort, another Florida case. In this situation, the board publicly posted names and addresses of delinquent owner. How many of you think that's a fantastic idea? Let's go put it on the HOA website, put it on the board at the community center. These are the owners who are delinquent. Even if we only name the lot numbers, it's still easily traceable to who is delinquent, and that is a no-no, slap on the hands. The delinquent owners in this case sued, claiming violation of state consumer protection statutes, which there is the FDCPA federal statute, as well as states have consumer protection statutes, including Utah, very similar to the FDCPA. Takeaways on this case: do not publish who is delinquent on their assessments to the general owners, let alone the general public, as to delinquent assessments. There are federal and state laws. Be aware of the potential liability, both associations who are not managed by a management company, as well as associations who have managers that manage the association. Liability can happen long before an attorney gets involved. Quinn and I's recommendation: hopefully use common sense, don't publish names, try to handle the matters privately and directly with the individual debtors. Next case, Pennsylvania case, M4 Holdings versus Lake Harmony Estates Property Owners Association. This case involves, and we're going to advance, maybe, the bylaws of the association state that one or more directors may participate in a meeting of the board via conference, telephone, or similar online communications equipment or other technology that enable all board members to participate in the meeting. So hence the prior poll question about passing a rule by the board via email without a meeting where there is a telephone conference or other virtual meeting where the technology enables all board members to participate in the meeting. The board adopts the rule via a series of emails. Are the email exchanges similar to telephone conference? In this case, the court found no. A meeting is a meeting where you can talk and hear all participants simultaneously. Emails don't reach that degree of communication, and therefore the rule adopted by the board was invalid. So be careful, even where we're in COVID times and people think, yeah, we can do everything via email. If the bylaws have language that really restrict it to telephonic type communication where one can hear and be heard by the others, then passing a rule via email only may be considered invalid. Next case, Los Diamantes Homeowners Association versus Goodman. This is an Arizona case, 2020. The CC&Rs have a provision that say they can be amended by consent, executed, and acknowledged by the lot owners. In legal terms, acknowledged typically means acknowledged by a notary public or similar document. In this situation, the association moved through with an amendment. They obtained the required consent by the members of the association, but the consent of each member was not notarized or otherwise acknowledged. The court, when the amendment was challenged, this was a rental restriction amendment. When challenged, the court found that consents signed by the members and acknowledged by a member of the board that they were true and correct signatures of the members, that acknowledgement by the single board member didn't constitute acknowledgement and consent by each of the lot owners. Therefore, the rental amendment was held as invalid. So be careful, read your documents. When they say acknowledged or signed, that language has meaning, and courts will interpret it as having meaning and may strike down the amendment if the proper process is not followed. Next one, Cohen versus Clark. This is a fair housing and competing disabilities case. It doesn't involve an HOA, it involves a landlord-tenant, but because we have fair housing requirements in HOA, it's important to be aware of this case. It's the Iowa Supreme Court. This is a real pickle for the landlord with two bad options. Battle of the disabilities. So Here we have a situation, you have one tenant that rents in a place where there is a no pet policy. The tenant has allergies to animals and can't be around pets. Now we have a subsequent tenant who applies and seeks a waiver of the no pet policy because they need an emotional support dog. So both disabilities are credible and supported and should be provided with accommodations. What does the landlord do? Well, he's looking at his pickle and saying, I'm in a bad position. Which pickle do I pick? Well, I'm going to try to accommodate both. So the landlord makes accommodations. Says, all right, for this tenant, use this stairway. For the tenant who has the pet, use the other stairway. Also, for the tenant who is allergic to pets, I'm going to provide an air purifier. That ends up not working, and the tenant who is allergic to pets brings a lawsuit against the landlord and the other tenant who has the emotional support animal. In analyzing the situation, the court first ruled in favor of the tenant who has the pet allergies, saying this was the first tenant there. Therefore, the waiver or the request for waiver of pet accommodations shouldn't have been granted because it violated the accommodations for the first tenant who had allergies to animals. But in ruling, the court said this is not a one-size-fits-all test. You have to consider the specific facts and circumstances. Just because the person allergic to the pets was the first to come doesn't mean that will always, the allergy to animals will trump the accommodation for emotional support animals. For instance, if you have somebody who is blind and has the need of a dog to guide them, that may trump the first tenant's need for a non-pet or no pet area. So be careful whenever you get a request for accommodations, weigh the circumstances and seek legal advice so you can put it on the attorney's shoulders and not yours. Right?
I'm gonna chime in again. That exact same situation we did litigate up here in Salt Lake. We represented some homeowners in a high-rise condominium that had a no pet policy, and when they had adopted that no pet policy years ago, our clients, the wife has very severe pet allergies, and we submitted documentation to the board supporting that. And so they had it on file, and we put them on notice that if anybody tries to request an accommodation, that they need to be aware of this, and basically, gave them information of those competing interests. And there was an individual, a person who was buying in from California, knew there was a no pet policy, sent information to the board that said, I need them as a emotional support animal. And the board denied the request for an accommodation to have that comfort animal, and basically said, we can't do it because we have this other person with these pet allergies. And the person who was buying said, you're violating the law, I'm buying anyway. So this person they hadn't closed yet when they were denied. They said, I'm buying anyway, and you have to allow me to have the dogs. And so she sued the association. Our client had to intervene in that lawsuit, and ultimately the judge came down similar to what you had, is saying, our client we had the medical documentation to support very severe allergies, was there first, put the board on notice, and the board notified the prospective buyer at that point of the denial and the background. And so the judge found that even with knowing all that, the owner who lived there first prevailed, and that the prospective buyer could have done more due diligence and realized that she would not receive that accommodation before purchasing.
Okay, so we have some Utah support as well on that.
It's only at the district level, so it was not, didn't go up to any.
Not published, but no. Okay, Next case, Hernandez versus Golf Course Estates Homeowners Association. This is another Fair Housing Act accommodation request. Again, boards, managers, be prudent when you receive a request for an accommodation. What's all the fuss about the bus is the theme of this one. In this situation, we have a tenant who rents property within an HOA. The HOA had adopted rules prohibiting buses within the association on the private streets due to the damage that they caused the streets, and the buses were known to have to speed through the subdivision and create other dangers. So a reasonable cause for the board to prohibit buses. However, this tenant has a special needs child that needs that a bus comes and picks the child up at the house. They requested accommodation to allow the bus for the handicap or special needs child to be picked up. Initially, the board said we'll allow this accommodation, but like many boards, after some time they reconsider and change their minds, and then they seek to enforce the prohibition on buses being within the HOA. Later, they get sued, and 2 days after the lawsuit is filed, the board again reverses and says, okay, we'll allow the bus to come in. The tenant of the parent of the child with special needs pursues the lawsuit, goes all the way to a published opinion here in Oregon. 2 days after the lawsuit's filed, the board has reversed their decision, said, we'll let the bus go, let the lawsuit drop. The plaintiffs wouldn't drop the lawsuit. The court analyzed the request, found that it was reasonable, and remanded back to be determined as to the damages and liability. So the important takeaway here, if you get an accommodation for a request, take it seriously, seek the advice of others if you don't have the answers. The school bus in this situation with a special needs child needing to be picked up with a special bus, the court is going to most likely go that direction, allow that to happen, allow the bus to enter the private subdivision. Okay, I skipped past. That moves us to the next section for Quinn. My bad. Too much on the auctioneer side, Scott.
Well, you skipped over the answer to our poll question there, Carson. So the issue of individual director liability, your last point on the PowerPoint, is still unsettled a little bit. So just
that is because
keep that in mind.
That is exactly my point. It is unsettled. Whether there's individual director liability, the court in that case remanded it back, strongly indicated that the plaintiffs would win, and stated that there was an issue of fact to be determined as to whether the individual directors had liability along with the HOA. So if you're a board member, don't take comfort that everything's going to be covered by the HOA. You may have individual liability if you refuse to grant a reasonable request for accommodation based on medical handicaps, medical needs under the Fair Housing Act and other applicable acts.
All right, thank you. Was there, Scott, did we have anything else, another sponsorship we need to focus on?
Other than this event, another one of our great sponsors are represented by these two gentlemen here, Jenkins, Bagley, and Sperry. If you are in Southern Utah and looking for attorney work and legal work, Jenkins, Bagley, Sperry would be happy to represent you. I'm sure they're always looking for business. But they are great and great partners to the HOA industry. Boards have done a lot of work in Southern Utah. I can speak to them.
Right.
Personally, have worked with both of these gentlemen. Okay, there you go.
Yeah, and I know we do have some on the attendees that are also up north here, and so with me joining, the Jenkins Bagley has expanded northward. So, the Wasatch Front, send us some, we'd love to help you out as well. Okay, I know it's getting late. And so those who have stayed on, thank you. I know talking about case law update and legislation is, it's getting you ready for bedtime. So I'll do my best to just wrap it up here. These last few things I'm going to talk about, this is potential future legislation. So this is, again, not passed, but these were a few bills that were introduced this past legislative session, and then which we think they may come up again next year if the senator or House representative who was sponsoring them may work on it more in this, during the year and present it again. And then we also have some issues that we've been discussing as a legislative action committee that we may prepare as we're still working through things. So the first one is there was Senate Bill 221. It was about short-term rentals. We talked about the accessory dwelling unit before, which did pass. This one would prohibit any ordinance limiting short-term rentals if the owner occupies the home. Remember, again, the accessory dwelling unit allows long-term rentals, 30 days or more. This one would have allowed Airbnb short-term rentals in there as long as the owner lives there. I think either last year or the year before, there was already some legislation that passed so that if there were municipalities that had short-term rental restrictions, they could not go on to the websites for these short-term rentals, Airbnb, VRBO, and identify the properties that were within their city limits or town limits, and then pursue enforcement action against the individuals who are violating short-term rentals. So they can't do that. This would have also stated that they cannot use tax revenue information to identify where short-term rentals are that may be in violation, or require them to have a business license, whatever it is. So this did not pass, but it was introduced late in the session, and there was some discussion on what does owner occupied mean. I think it's pretty obvious to us, but there were some discussions on that, and so the sponsor did not push it and basically said, I will work on clarifying that. And the sponsor of this bill was also quoted in the media last week as stating that he hates HOAs. So that's not a good sign for us going into next year, because he is one that has some clout on Capitol Hill. And so I anticipate that this may be back up in the 2022 legislative session. We had another bill that did not get much momentum, which is a good thing. This is the one I want you to remember on that equine holdings case that Carson talked about. So this was a bill that would have put more requirements on what has to be included in any recorded document. So, this is going to be a deed, a plat, anytime we're doing an amendment. Think of even filing a lien or a notice of default for delinquent owners. So anytime you're recording a document, it was going to require that you have the location of the property. It's already common that we put in meets and bounds, especially with amendments, or we're just with a lot, we're just putting in kind of that quick description of what's there. Or you can do a survey, which can be expensive. That equine holdings, again, that's the one where the legal description didn't quite close or match up. Or you have to put in the lot, block, or track number of a previously recorded plat. If it was just that requirement, it probably wouldn't be too bad for us. We can get a lot of that that's already on recorded documents. The main concern is the next one. Sorry, that estimate of rent, that was a carryover from another slide that we need to delete, but any easement, right-of-way, or reservations. So this is the big one. Think about that. Anytime you're going to be recording a document, you have to identify every easement or right-of-way or some reservation, a property interest that somebody has in that property. You're going to need a title report for every time you're recording a notice of lien. That's going to drastically increase the costs to a delinquent homeowner. You're going to need a title report every time you're doing the amendment, which maybe isn't a bad thing. And then think of what's the liability, or how does that impact future enforcement if the HOA does not include a certain easement or a right-of-way? Are they liable for that? What if they fail to include, some specific easement or right-of-way on there? Does that give rise to enforcement issues? So that is not a good bill. We're glad it did not get much momentum, and we still don't know what the impetus was behind this, but hopefully we can find out if the senator intends to introduce it next year. This other one was, this was actually worked on by another HOA attorney and a member of our Legislative Action Committee. The background here is he had a client who had purchased and basically an entire building in a condominium project, and then it turns out that the developer did not pay all the subcontractors, and so there was a mechanics lien put on the building. And we know that the Residence Lien Recovery Fund is put in place so that people who are buying residences, if that happens, they can look to this recovery fund, and that will pay the subcontractor. Well, for this individual who had the building, unfortunately for him, the definition of a residence in the statute did not include a condominium unit. So he did not qualify, which meant he just bought this entire building of condominiums, and then he had to go and pay the subcontractor because the general contractor did not pay for that. Now, of course, he has a claim against the general contractor, but you never like to buy into litigation, which is what happened in this situation. So the House bill was introduced. It did not pass. We thought it would early on, but it did not. And then there's actually some efforts where they're saying they're trying to do away with the Residence Lien Recovery Fund in the future. So, which would be too bad. I think it's been used, to help these innocent homeowners get rid of some liens, but that is a concern if it goes away in the future. Some other legislation that was actually went through legislative drafting. It was not assigned a bill number, but we were informed about it well in advance, and so we were able to work with the representative who was sponsoring it, and he was actually doing it as a favor to a former Utah legislator who, since he was out of the legislature, moved into an HOA and has been having a bad experience. He's in there with these boards who are holding closed board meetings for everyone, or they're just basically, informally talking about things and determining that is a proper way to do business. And so we got wind of that. I was able to speak with him. It turned out he and I had a relationship while he was on in the state legislature. And so I was able to, me and somebody else were able to meet with him, talk about his concerns. We are going to be addressing some of these issues going forward to see if we can tweak the open meetings bill to address some of the concerns. But what he was trying to do was to treat board meetings more like public meetings, and requiring all the formalities of that, all the notice requirements. The biggest thing that would have hurt us in the HOA realm is it would have prohibited all actions without a meeting. Scott, as a manager, how often do boards take action without a meeting by email? Quite often, right?
This would be awful.
Yes, I mean, the Utah Revised Nonprofit Corporation Act has that statute and a provision that allows boards to take action without a meeting, and it's relied upon a lot. If that were to be taken out, you'd be having a lot more board meetings. They'd be going a lot longer. So that would not be great. And that is one of the reasons that this person who was behind it was able to back off, because we were able to explain to him some of the practical reasons of why that would not work well. One of the other things that he had in there was right now, if an owner requests notice of all meetings, it has to be sent to them by email. This would do away with that and require the HOA to send notice of all meetings to all owners at least 48 hours, and they'd be sent by email, and they also have to include a meeting agenda. If the HOA has a website, they also have to post it on the website. So, and then the statute included, the proposed language included a provision that said, if they comply with everything except for posting on the website, then a court cannot invalidate or void the decision or the action taken by the board. Which, if you look at that by that language, if the board were to fail in one of those other procedures that's up there, a judge could void everything. And so, that can be problematic if you get quite a ways down the road and somebody's trying to say, you were deficient on this one little procedural issue. We're setting aside all of the actions that you've done. So again, we'll be working with the individual on some of this and trying to address his concerns with some legislation that may be introduced in 2022. This is another one.
Quick question on that.
Yes.
Quick question. Are meetings of committees, such as landscape committees, required to be open to members if it's not addressed in the charter or documents?
Yeah, my recommendation is always have those open, just like it's a board meeting. I mean, it's a subcommittee, but it's always best to have that open. If there are other ones, I mean, you can still have them in closed meetings if it's for one of the purposes of the statute.
Litigation.
Litigation committee. That one can obviously be closed on everyone. But if you're having these landscape committees, my recommendation is always have them open. I mean, not many people participate in a regular board meeting. You're going to have even less in a landscaping committee. And really look at the policy. I mean, you want to be transparent. I'm a big believer in pushing transparency. It can cut down on a lot of issues. I mean, sometimes you get where you have the distrust in the communities because of the lack of transparency. If you can promote that, I think it can really help breed a sense of community in your association. So, okay, this is another legislation we thought was going to be introduced this session. It actually was not assigned a bill, but it'll probably come up next year. This is the same senator who's sponsoring it is the one who said he hates HOAs. So it may come up, although this one, is a little more practical. The impetus of this is, unfortunately, you have a U.S. Postal Service worker who was just putting some mail into a community box, and you know how those are. They're located right kind of in that park strip, and they load it, standing in the shoulder or just the gutter area. And this Postal Service worker was hit by a car, and so again, that's another tragic situation. And so what this legislation would do, at least we haven't seen the language, but what's been discussed is it would modify the location or the direction of the mailbox. And so there's been talk about just turning it around. And so the postal worker can stand on the sidewalk and load it. The problem with that is that means all the homeowners would then be standing in the street as they're getting their mail. And so the danger of getting hit is still there. Or the other situation was you would put the mailbox on the other side of the sidewalk. So not in the park strip, but the other side closer to where the homes would be. And so that seems like a practical way to address the safety issue. The concern that we have at this point is what about existing associations? You can do one thing going forward with new development, but would the language of this statute require any existing ones to be relocated? And if so, who pays for that? If it is required to be relocated, that expense likely falls on the association to do that. Another one that we've been talking about, this is, and we've been talking about it for a little bit, is rules. This was not introduced. We're still working on some language as a legislative action committee. And really, we want to clarify what constitutes a rule, and you know, it would include a policy, guideline, restriction, procedure, regulation, obviously something called a rule, and then probably the bigger thing that we're trying to look at here would be putting some limitation. Right now, we've talked about doing 18 months to challenge any rule that's adopted by the board. You know, I've been involved in situations where the homeowner is going back years and trying to set aside rules that were adopted because they're saying they were adopted improperly, and how that directly relates to the issues in the lawsuit. And so by putting a limitation, essentially it's an 18-month statute of limitation on that, it can avoid those situations. So we did at the community association days in the Capitol just in early February, I think that was, right, Scott? There was a poll taken of people participating in that of, do they want it longer than 18 months or not? And many people wanted it, I think people were saying 6 months. They wanted a 6-month limitation on that. So right now in the language that's been discussed, we had it at 18, but based on some feedback, we may be going back and shortening that up. But we obviously need to balance the interests of you know, both the association and then the homeowners there, and try to say what's the right balance. So that's what we're trying to do. Records, this one, we've been talking about this one for several years. If you look at the Utah Revised Nonprofit Corporation Act, it includes certain records. It's specifically identifying those meeting minutes, action taken without a meeting, records. Well, I'm not going to read them all. You've got them there on the slide. Those we know are records, but the Nonprofit Act, in another section, it states that people are also entitled to inspect or receive copies of, quote, any of the other records, unquote. And that language has resulted in litigation in several cases. And so the question is, what does that mean? And trying to get a definitive answer, you know, nobody's taken it up to an appellate court level to get that. Other than there was one, let me back up. There was a case several years ago about a records request that was at the appellate level, but it was ruled on a very narrow issue and did not go into defining what records were. So even though we have a little bit of information on that, it does not go as far as what we need it to clarify this language of what is any of the other records. And so what we have been talking about as some potential legislation is, you know, for community associations, that would obviously include the recorded covenants. The bylaws are already in there in the Nonprofit Act, but we'd also say the rules, budget, and other financial statements, reserve analysis, and a certificate of insurance. The question that's still being debated with some people is, well, does this include board member emails, text messages, notes, violation notices, and owner complaints? So we are still working through that, and we'll see how that language finally comes out. Fines, main thing here, we're looking at trying to reconcile the process in Condo Act, Community Association Act, and clarifying notification language, especially with regards to repeat violations within the 1 year and continuing or ongoing violations. And then the last one, which I know we're all happy to get there, reinvestment fee. What this is, we know that the maximum amount allowed by statute is 0.5%, and this would be if you have multiple associations, so a master and a sub-association, how much can they get? Right now, I mean, some are saying we can get both 0.5%. Right now we're discussing they would have to split that, so they could each get a 0.25% or some other amount that they would have to agree to. So those are the issues that may come up in the 2022 legislative session or even beyond that.
Perfect. Thank you, sir. Thank you, Carson. Thank you, Quinn. We want to give another shout out to our great sponsors that help sponsor this event. We also want to give a shout out to those members of the board down here in the Southern Utah section of the Utah chapter of CAI, Camry Naze, Dave Houston, Greg Gardner, Luke Udi, and Carson Bagley, as well as myself. I want to thank all those that participated here. This has been recorded and will be posted to the UCCAI website. So check back there probably first next week, and this will be posted. But thank you all. If you have questions, feel free to reach out to Carson and Quinn or your management company. Myself, happy to answer any of your questions that you may have. Thanks, and we'll let you get on with your evening.
Thank you.
We'll have the tongue twister competition next time. So thanks, everyone.